Now I'm recording. Aren't you cold, Miguel? Up there in front of the water and the bridge and stuff?
A little bit. That's why I need a hoodie.
Oh, good response, Miguel. That was quick. I like that. Okay, so we talked about contract law, and actually, we briefly talked about the fact that a verbal contract is binding. And then we talked about ways of resolving disputes, and we talked about litigation, and specifically, we went through the litigation process. And I told you that you would be responsible for this in the exam. So when you get your exam, you will be asked questions. And maybe I could ask a question like, explain using the example I gave in class why it's important to answer a claim when you get one, right? That would be a great question. Can anybody answer that?
I can.
Okay, go ahead, please.
You gave the example of I forgot his sin. I'm sorry, but the 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 defendant did not answer, and you guys had to stake him out, and he still managed to avoid you. So you asked the judge multiple times for um a default decision. I forgot the
Default
name.
judgment.
And
Yeah.
a default judgment. And eventually the judge was like, okay, try one more time. And he still didn't respond. And then you just got what you wanted.
Very good. And then to add on to that, we he actually went back to court, and the judge basically said it's too late. And then he appealed that decision, and he lost the appeal. So he lost his house actually. Um, but good. So that Katerina was obviously paying attention in class that yet last time and captured the kinds of things that you'll need to know on the exam. Very good. Good job. All right. Yes, you do. You do. That's the way of bypassing artificial intelligence because artificial AI, ChatGPT, will not know the example that I gave in class. So that's why it's important to do that. Okay, so we talked about that process. We talked about how important it is to think about whether or not it's worth going to court because court is very expensive. We didn't go over this video, but which we're going to do today. This is about alternative dispute resolution. And then we specifically talked about negotiation, mediation, and arbitration. We're going to spend more time on that when we go. Today, we're specifically talking about alternative dispute resolution. And then we got into the categories of law, the kinds of things that law do. And then we talked about the broad categories. We talked about international law versus domestic law and the fact that there's no enforcement mechanism for international law. And then uh, we didn't watch this video, but I think we'll have time to watch it today, which is about the structure of the courts. Um, and then we talked about substantive and procedural law and the differences between them. The substantive law is basically what gives you your rights and duties and obligations. And then the procedural law is the process that we have to go through to get our rights taken. And then we talked about public law, administrative, criminal, and constitutional. And we talked about the fact that criminal law is actually um, the prosecutor or the crown who represents the crown or the king versus the person. So it's actually the government versus you in criminal law, and the fact that victims actually don't have any rights because it's not their case, at least not in the criminal law system. And then we talked about administrative law, and um, and then we talked about constitutional law and the fact that the Constitution is the highest law in the land. And then different kinds of private law, tort, contract, family, wills and estates, property, and employment law. Tort law is the law of injuries, and that could be whether or not you injured someone on purpose or by mistake. it doesn't matter. That's what that area of law covers. And we're going to spend part of today and the next two classes after that specifically talking about tort law. One important part about tort law to remember is that there is no tort code. So you actually have to learn tort law, all the different aspects of it based on the common law, so previous decisions by the court. And then wills and estates, there is a Wills and Estates Act, so that's one area of law that is actually covered by civil law, meaning that there's a law that's made. And with property law, some of it's covered and some of it's not. And I told you guys this great video is going to actually review much of what I've spoken about in class. And then the sources of law, where does it come from? This is where we left off in the last class. So where does a law come from? Where do we find the law? The Constitution, very good. Where else? The court? What do you mean by that?
Maybe by experiencing
Oh, hold on. I guess you can't
something.
hear Nilufar.
Okay.
What's your name again? Saloni's just actually talking. You probably can't hear her. So go ahead, Saloni. Very good. So Saloni was saying that in the last class, we talked about how the law can be made after the fact, which is a really interesting aspect, is that if you do something wrong and it's not on the books, the judge can say, there's a new law that applies to what you did, which you didn't know when you did it, there was going to be a new law. So it's applied retrospective. And that's the way the legal system works. So under the under common law, law is created by the judges. Very good. Where else does it come? I'm sorry, you're going to say something, Nilufar?
Actually, I want to say we can apply law by experiencing some relationship between people or between people and governments, and then creating some laws according to past experience.
What do you mean by that? I don't understand.
I couldn't explain. Actually, in the past, when people experiencing something between them, governments actually come up with some laws.
Oh, okay, I get it. I get
Yeah,
it. Okay,
yeah,
so,
yes,
and you're right. So that's through legislation, right? So
yes.
basically, we can create legislation. That is definitely one way that law is created by the government through legislation.
Yes. Thank you for completing me.
And let's look at this here. So basically, you guys got them all except for regulation, which is the same thing. So Constitution, right? Common law, which Saloni mentioned. Saloni? Okay. Statutory law, which is what Nilufar was talking about. So that's when they just actually create law through legislation. Court decisions related to common law, but it's a little bit different. So when we create a legislation, the court actually gets the final say. They get to decide what the law means. So it doesn't matter what they put on the books. It matters what the court says it is. And so the courts then, in Canada at least, they kind of get to determine what the law says at the end of the day. And they can use the Constitution to change laws that they say no longer apply. So let me give you a good example of this. About 15 years ago, a sex worker challenged the criminal laws on prostitution in Canada. And she said that those laws were unconstitutional because they didn't protect her, but they protected the people who were using her service. Because she couldn't, she said it was much safer for her to be able to operate out of her own home rather than being standing on the street with her thumb out, trying to get a ride, get a customer. Because in her own home, she could have protection. And, when she gets into someone else's car at night, who knows, right? That could be her last day. Interesting challenge. And actually, the courts agreed with her and they struck down the prosecution. And that's why you don't see in Toronto or anywhere else in Canada, you won't see people on the street who are sex workers, right? They'll work out of their home.
Sorry, Professor. Can you repeat the example once more because your voice is sometimes too low? I didn't understand clearly.
So what I was saying is that, that sounds a lot better, eh? I can hear myself. I was saying that the criminal law was struck down by the Supreme Court of Canada on the basis of it being unconstitutional because it didn't provide equal protections as it's supposed to be under the law to sex workers and the people who are using their services. So this sex worker brought this challenge and she said, look, when I get into someone's car late at night, they can take me wherever they want and I'm basically I'm captive to them and I have no protection. And if I could operate out of my own home, then I'm much safer there. I'm much more safe out of my own home because I can have someone else there to protect me or I can, call the police. I'm not stuck in someone's vehicle. And the court agreed with her and they struck down the prostitution laws overnight. And they basically said to the government, you need to go fix this because it's not providing equal protection. And the other thing that she said, which is absolutely true, is that when the police do raids, they don't typically go after the men who are using my services. They go after the women who are providing the services, and that's just not fair. Like, you should be going after everybody equally if you're going to do it. And again, there was lots of evidence to suggest that was true. And so they basically struck it down. And what I'm trying to say here is that at the end of the day, the court gets to decide what the law is. They get to decide what the law means. And it doesn't even matter what the government says they think the law should mean. The court still gets to decide what it means, regardless of what the government says. And then administrative regulations. So what's the difference between a legislation and a regulation? Does anybody know?
Professor, just one more question. So the sex worker actually challenged the constitutional law, not the criminal law or something like that?
They can interpret the Constitution. So it means they get to decide what it means. They can't change the Constitution, but they can decide this is what it means in this circumstance.
Okay, so my question is actually the workers actually, which law she actually challenged? Is it
The
constitutional
criminal
law?
law.
The
Criminal
criminal
law.
law? Okay.
On constitutional grounds.
Okay, noted.
Right. So the Constitution says that any law must be applied equally and fairly, and everyone has equal benefit of the law, right? So she said that criminal law about prostitution did not apply equally and did not provide equal protection. So what's the difference between legislation and regulation? Anybody know? Right. So Favor says that the regulations are under the legislation, and that's absolutely correct. And the reason that we do that is that every time we want to change the legislation, we have to go back to Parliament, have a debate, and get everybody to agree, which is not easy. And even on the easiest days, it's not easy. So think about this. The Income Tax Act, every year they decide what tax you pay and how you pay it, right? Can you imagine if they had to go back to Parliament and have a debate to change the income tax rate every year? It would be crazy making, and nothing would ever get done. So the Income Tax Act says that the government has the right to raise income taxes, but it doesn't say the rate. Those are in the regulations. Now, regulations can be changed overnight, and they don't need any permission, right? The government who's in power can change the regulations very easily. And that's why your taxes can change every year, and that's why, you know, what your benefits, the kind of benefits you get through the taxation system, and the amount of tax that you pay, that can all change very easily. But the fact that you have to pay tax and how that tax is collected, that's in the legislation. The regulations is about how it's going to actually work. And so regulations are things that can be changed really easily. And every legislation, every single legislation has a set of regulations. So typically the legislation might be a few pages, the regulations might be a few books. So a lot of the meat is actually in the regulations. And you have to keep up on the regulations because they can change very easily. So the Constitution, as we mentioned, it's the most important law. It says how the government can operate, what our fundamental rights are as citizens. That's kind of important. What are the limits of the provincial and federal government for passing laws? So there are three main sections, Section 91, 92, and 93. Section 91 says the federal government has the right to make legislation in relation to A, B, C, and D. Things like the military, maritime law, communications, anything that's in a federal banking law, anything that's federal in nature. Under Section 92, it says, well, the provinces also have the right to pass laws in certain areas, healthcare, education, everything that's sort of local in nature. Now, the interesting thing about the Constitution, it says, and these two things means that each party, i.e. the state or the province versus the federal government, is supreme in their own realm. So if I'm making a law, it means that the provinces can't make laws that affect the military. They can't make laws that affect communications. They're not allowed to without the permission of the federal government, and vice versa. So the federal government cannot pass laws about healthcare. But then I mentioned last time, but we do have universal healthcare. How is that? And that is on the basis of taxation. So the federal government collects the money, and they say to the provinces, if you want this money, then you got to agree to do some things that we want to see, like the fact that you can't charge people for healthcare. So we have a universal healthcare system in Canada. That means that no province is allowed to charge a permanent resident or Canadian citizen for healthcare. They're not allowed to, even if they want to. Even if the person wants to pay, they're not allowed to accept money. Okay? Why do you think they do that? Why do they have that system where, like, isn't it better that if people want to pay, they can pay and maybe get faster service? Why do they have that system that you can't, even if you want to, you can't pay?
Because then why are we paying our taxes on this?
No, but what if you're Miguel? I mean, some things, if you want to get a hip surgery, for example, you might have to wait a year to get it because lots of people want to get them. And what if I say, well, you know what? I'm willing to pay for my own. I wanted to get it next week, and I'll pay for it myself. I don't want the government to pay. You can't do that here. So why do they say that you can't pay?
Because otherwise, like, they can start charging whatever they want, and there's no control.
Right. So what we want to make sure is the whole idea of universal health care is to make sure that everybody in Canada has equal access to health care. It doesn't matter how much money you make or where you're from. Everyone's supposed to have access to the same system. And if we allow people to pay, it means that they'll have access to a different system. And we want to make sure that everybody is the same. That's sort of a really important principle for healthcare. I can tell you, I've used the healthcare system a lot in the last year, and I don't know how those people do it. Actually, my brother's a doctor, so I do sort of have an idea of how they do it. But the care I got was supreme care, amazing care. And if I was in the United States, the care I got would have easily cost me $200,000, easily. And it cost me nothing. So I got really good care for nothing. And you will hear people talk about how these long lines in hospitals. And my advice to you, once you guys become permanent residents, unless any of you are, stay away from the emergency room. Go to a clinic. If you go to the emergency room, they use what we call a triage system, which means that the most serious patients get seen first and everybody else waits until there's time. So when I went to emergency, I was in surgery within 20 minutes, right? There's none of this waiting around in the hallway that people talk about, because if it's really serious, they're going to see you right away. But if you go in for, if you go in for something that's lesser, go to your clinic. And, you're going to be waiting there too, but not for a day, which is what some people wait for in the emergency, right? They wait for 24 hours if they've got like a cut finger or something really minor. Okay, so common law comes from the British system. The idea was, and by the way, we still have this in some areas in Canada, like in Northern Ontario and Northern British Columbia, we have traveling judges. And the idea was that these judges, and they still do, they go to one community for a week and then they go to another community for a week and they just kind of move around. And that's how all the judges were at the beginning. And what they realized is that these judges were making really different decisions. And, we want the legal system to be predictable. And so what they said, let's share our decisions. Like, let's decide that we're kind of, going to decide together about things so that people can have some sense of being able to predict what's going to happen. And that became the basis for the common law. And so eventually they wrote them down, and then they came up with this idea of a precedent. So that, when we're deciding a case about something, if it hadn't been dealt with before, that other judges would agree to follow along with us. And we still have this idea in our court system. But then the common law system has begun to erode somewhat with the passing of new laws and statutes, because once you have a statute, it's easier to determine how the law is going to decide. But in Canada, we still have common and civil law. So as I told you, like in tort law, contract law, it's all common. In criminal law, for example, or estate law, most of it is, criminal law is all statute. Estate law is mostly statute, which takes us to the next thing, and that's the things that are passed by government. And the whole idea here is that, there ought to be a law about it, right? So they create a law about it. And, for example, the Highway Traffic Act, if any of you drive, you should recognize that there is a set of legislation that determines how you operate on the roadway. And that's all under statute. So there's nothing that's really left to guess about. And then we have court decisions, which we already talked about. That could be through common law. It could be by interpreting what statutes mean, which we talked about in the context of the criminal law and prostitution, or it could be by judicial review. And that's where the government just declares something as being unconstitutional. And then we mentioned briefly administrative regulations, and regulations are attached to every kind of law. So wherever we have a law, we have a set of regulations that determines how the law is going to be applied. And the next thing that we are going to talk about is the principles of natural justice. And these are actually really the foundation of how our legal system works, and they're very important to know. So has anybody ever heard of this before? What is natural justice? You ever heard this term before? Nobody? Funny how everybody looks away from the camera when I ask a question like that, eh? Parisa was the only person who stayed looking at the camera. She's confident. Good for you, Parisa. Hold your own. So the idea of natural justice is that there ought to be certain things that are applied in every case when someone's making a decision that is going to affect somebody else. And so they are applied in administrative law, but they're actually applied to every decision that's made. It's about making fair decisions. And this gives us some sense of the kinds of things that we ought to think about. So would you want a person making a decision about your future who maybe is related to your ex-wife? When you had a really bad divorce? Would you want that? You're shaking your head? No, you wouldn't want that? Francis is smiling. Do you have an ex-wife?
Oh.
Well, of course you don't, right? We would think that that would be unfair. And so there are certain rules about who gets to make the decisions, under what circumstances they can make those decisions. And these are considered very, very, very serious rules. And so we're going to talk about all the different aspects of that. But before I do that, I'm going to show you a video where he, I think, does a really good job of specifically talking about natural justice. So let me just put that up here. And then afterwards, we'll talk about specifically what this says. Oh, why is it doing?
Council.
Can't copy it? Huh. Well, I know what I have to do. I have to do this and then do it. No, it's still not working.
Welcome to you, Council. Procedure.
Can you guys see the video and can you hear it if I do it this way?
Yeah, we can see
Okay,
it.
good. Can you hear it though?
Fairness impacts all
Yeah,
of
we
us.
can hear it.
Whether we're in the court system or not, we are always dealing with procedural fairness in our everyday life. Now, in the court system, you may have noticed that a number of my lectures are about procedure, whether it's rules of civil procedure, whether it's small claims court procedure or family law procedure. In court system, the procedures are often laid out and defined in great detail because courts are concerned with the process by which the decision making is done, and that the court is trying to ensure that every party who is involved in a court process is entitled to a procedural fairness in that system. But what happens in our lives that are outside of the court system? How does the procedural fairness impact all of us on a daily basis? That is what this lecture is about. We begin with our usual disclaimer that this lecture is not legal advice. So if you have any specific questions regarding your issues, you should contact a lawyer or a paralegal or the Law Society of Ontario for a referral. So who is affected by procedural fairness? As I stated, the answer is all of us. So when we're dealing with public or quasi-public institutions, we're always dealing with issues of procedural fairness. So for example, when you apply for employment insurance, when you're laid off from your employment, or when you are ill, or when you are on maternity leave or parental leave and whatnot, you are dealing with procedural fairness. Social benefits, welfare, disability matters, all are dealt with procedural fairness. When you are engaging healthcare, you're attending hospitals, universities, colleges, when you're applying for license, for example, driver's license, your health card, all of these instances are examples where procedural fairness is at play. Even in private institutions, for example, when an employer conducts a workplace investigation, that investigation is bound by procedural fairness. So there are so many scenarios in our life where we are engaged with procedural fairness. So what is this procedural fairness? Procedural fairness is essentially fairness of the process, the procedure by which a decision is made. So procedural fairness is not concerned about what is the end result, what is the end decision, but the process by which that decision is made. And how do we understand this process? Let me give you an example. So A complains that B has harassed him. A comes to you, you're the employer, and that is the complaint. Now
I want you to listen to this this example very carefully because it's really well laid out in terms of procedural fairness.
Make the decision to penalize B without an opportunity for B to respond to the complaint. You believe that B has been harassing other employees all the time. There has been many instances in the past that B was reprimanded or punished for his harassing behavior. On the other hand, you know A very well. A is a great person, likable person who doesn't lie, doesn't cause trouble in the workplace. So you, on the basis of that information, you just believe that there is no need for B to respond to these allegations. He must have done so, and you go ahead and penalize B. That is essentially a violation of procedural fairness for B, because you have denied B an opportunity to respond to that very complaint. And you're taking a shot in the dark because there's 50% chance whether B harassed A or not. But by failing to give an opportunity for B to respond, you have violated his procedural fairness. So that's an example of how procedural fairness.
So can someone explain that to me? What was he saying there? Sorry, go ahead.
B was not given opportunity to be heard.
Okay, just hold on a sec. Just hold on a sec. Everyone has the right to a fair hearing. So in this case, someone comes to you and says, such and such harassed me. And you know that this person has harassed people before. And so you just decide to fire them. You can't fire them, right? You have to actually hear their side of the story. But it even goes beyond that. So if I'm the person who there's the allegations have been made towards, I also have the right to bring my own evidence. And I have the right to cross-examine that person. So let's say the person comes to you and says, you're the boss, and they say, Bachelor is harassing me, but I don't want you to tell him because I'm really scared. Well, what that means is you'd have to say to them, well, I'm sorry, I can't guarantee that you know, if you're going to make an allegation, you may have to back it up. Because that person has a right to actually bring evidence and cross-examine you and ask questions about what happened, right? So it means that you can't fire someone on the basis of someone saying, well, I don't want you to tell anybody that I said that. It also means that, and he'll talk about some of these in the video, some of the other parts that are attached to procedural fairness are that I have the right to have someone help me. So I can get a lawyer or a friend or someone else to assist me with my, my defense. I have the right to an adjournment. So it means that, you know, maybe I'm not ready to go, or I haven't had a chance to get a lawyer and I'm going to get a lawyer. And, you know, I remember I told you guys, if someone serves you documents, you have to respond. But one of the ways you can respond is by contacting a lawyer and say, I want to get a lawyer. I need a bit more time. They actually have a professional duty to give you extra time. And that's because of procedural fairness. We don't want to take people by surprise, or we don't want to force people to, you know, come to court when they're not ready to come. We want people to be ready when they're ready. Now, that doesn't mean that you can you know, every single time come to court and say, I need an adjournment, I need an adjournment. There comes a point where the court was going to say, well, come on, you know, you've had many adjournments now. Like, let's get to business. Okay, good job.
Works. It's in the process. What are some of the basic elements of procedural fairness? There are essentially two principles, and they're in Latin. The English is, number one, the right to be heard. That is one procedural fairness principle. And the second is the right to be judged impartially. Now, these procedures, they manifest in so many different ways. So let's go through the examples of how procedural fairness may work in different scenarios. First of all, you should understand that the threshold that engages the duty of procedural fairness is quite low. And what is that threshold? If an individual's rights, privileges, or interests are at issue, then the procedural fairness is engaged. And this is sort of a very, you can see this is a very low threshold, right? So because if you are affected by a decision, then obviously your interests are at issue, right? So if you applied to a certain university and you believe that the admission process was unfair, of course your rights, of course your interests are engaged in that process. So procedural fairness, number one, has a very low threshold to be engaged. So almost, I mean, I can't imagine any scenario where you may not be entitled to procedural fairness, but that's what it is. The threshold is quite low. Second, what you want to remember is that procedural fairness is flexible and entirely dependent on context, right? So the two principles that I've talked about, the right to be heard and the right to be judged impartially, they are applied in the specific circumstances of the case. And that is why it is important to know that what may be a breach of procedural fairness in one context may be completely fair in another context. So the procedural fairness is context-driven, and the courts or the administrative bodies are looking at the specific context of that case to decide what is procedurally fair in the circumstances of that case. The two principles we've talked about procedural fairness, the right to be heard and the right to be judged impartially, have different manifestations in different circumstances. So I have listed some of the examples of these manifestations. Number one, no undue delay. So if it is fair for you to get a decision in 30 days and you have not received the decision for 6 months, then that may be an undue delay, and that may be a violation of your procedural right for procedural fairness.
And I think I mentioned this before, but the delay, for example, even if there's an allegation that you've committed murder and your case is not brought fast enough, like within a year, you can actually ask the court to set aside the charges and you'll be successful. There's lots of people who've gotten off with serious crimes because their case wasn't brought fast enough. So that's how serious this is taken.
You're obviously entitled to a fair and impartial process. We talked about it. You are entitled to right to know the case against you. So in the example that I've given, B is entitled to know what is the complaint against him, who made the complaint, so that he could respond to it. And then right to be heard. Then B is entitled to be heard. B is entitled to say his truth, to say his side of the story, so that the decision maker can make a just and a fair decision. Legitimate expectation means that if you are a person who is affected by a certain decision and there are certain expectations given to you for that process, then those expectations are complied with. So for example, we know that in rules of civil procedure, a party is entitled to file its defense within 20 days or 30 days in certain circumstances. Now that means the party is entitled not to be noted in default until that time runs out. If that party is noted in default earlier than the time, then that means that that's a violation of a legitimate expectation of that party. Similarly, if you are entitled to a decision in 30 days and you don't get that,
I don't think you captured this well, because it's not just a legitimate expectation, it's actually the law. Let me give you an example of a legitimate expectation that's more realistic. You guys are students, and let's say there's an allegation that you've committed academic misconduct. So you've plagiarized a paper. Well, there's a whole procedure that's set up for that, right? So they have a committee who will meet, and that committee will act, they'll hear evidence from you, evidence from the professor, they'll give a written decision, and there's a whole process in place. If they don't do that, there's no rule, there's no law that says they have to do that, but they've created a policy. And so once they create the policy, you have a legitimate expectation that that's going to happen. So that's a better example, because what he's talking about here, those things are actually laws. I'm talking about things where there might not be a law in place, but there's been an expectation created because there's policies and procedures that have been put in place to deal with these kinds of things, right? So let's say in that circumstance, they just say, well, the professor is going to make the decision, they get to decide. Well, that would be against what your legitimate expectation would be, okay? Mm-hmm. We're going to get to that. Okay, so that's actually the next slide after this. So the question was, when is it contextually driven, right? So we're going to come to that.
Decision for 6 months or a year, then that's a violation of your procedural right for legitimate expectation. There's also a right called freedom to conduct one's own case. And this is, again, specific to a scenario. In this case, Human Rights Tribunal had imposed on a party to provide will-say statements for certain witnesses. And the party said, we are entitled to present our case the way we want it. You can't force us to present certain witnesses' evidence. And they challenged that decision, and the decision was overturned by the divisional court on grounds that the party was entitled to present its case the way it sees fit, that it cannot be imposed on the party how it should present its case. Right to reasons. In certain circumstances, you may be entitled not only to know the decision, but to know the reasons for that decision. An example of this right was, in one case, a probationary police officer was terminated from his employment without giving any reasons, and the employer took the position that the Police Act allowed them to terminate the employee, and therefore they didn't need to provide any reasons. And the court said, no, you are required to provide reasons to this particular probationary officer because it is procedurally unfair for him not to know the reasons and not to have an opportunity to respond to those reasons. So in certain circumstances, this may be your procedural right to know the reasons for the decision. Similarly, in workplace investigations, the person who is being penalized because of the outcome of that investigation may be entitled to know the reasons why the decision was made against that party. In circumstances where credibility is an issue, we know that oral submissions are important. So in certain circumstances where a decision-making body denies one party to make oral submissions, even though there were credibility issues that were at play, then it may be held that that was a denial of procedural fairness. In some circumstances, you may be entitled to an adjournment of certain decision because you need a little bit more time to respond to certain things. And it may be considered that if an adjournment is not given to you in those circumstances, that may be a violation of procedural fairness. In some circumstances, we know that, for example, in workplace investigation scenario, Occupational Health and Safety Act imposes an obligation on an employer to conduct investigation for harassment. But in some other circumstances, you may be entitled, based upon your complaint, you may be entitled to have an investigation. And if the party or the employer in that circumstance does not conduct an investigation, then that may be a violation of your right. So what is the takeaway? You have to always, always, always watch out for procedure. The devil may lie, devil may work behind the procedure. Greatest injustice may be happening because of lack of procedural fairness. So this is something that you need to always watch for. You need to always claim procedural fairness, and you need to always follow procedural fairness with respect to your rights and obligations. Thank you for watching.
Okay, so let me go back to these slides, because I promised Favor I was going to go over. Yeah.
Justice Move. Police officer, what if the employer has already told the employee that
I don't understand your question.
like what if the employer has I don't know these.
It doesn't matter. They still have to give reasons. And if they don't give reasons, that may be a reason for basically having the whole thing terminated, the whole decision terminated, because the decision's invalid, and they would have to start again and do it all over again. Yeah. Mm-hmm.
Hi, Professor.
Okay, hold on a sec. So someone's talking. Just one.
Okay.
Right. Okay, but we're getting into a bit of a different area here. So you're talking about what rights would an employer might or might not have to dismiss you. And we're going to spend 2 full classes on that. So that's under the area of employment law, and there's lots of things going on. There's no way we could deal with that here justifiably, because we have the Employment Standards Act, we have common law. So we have legislation about what's acceptable, and we also have common law about what's acceptable in those circumstances. And they both work together to create the employment law. So it's very, very situational specific. Okay, so it involves a number of things, including the age of the person, how long they've been there, what kind of job it is, et cetera, et cetera. So when we get there, I think you'll see how this stuff is actually very, very complicated in the terms of employment law anyways. I'm sorry, did someone want to say something?
Yes, I have a question.
Yeah.
So, is natural justice the same as procedural fairness?
Yes. Procedural fairness is part of natural justice.
Okay, thank you.
It's part of it. It's part of it.
Okay.
I'm trying to find my slides again here. What did I do with my slides? Did I move this? Oh, okay. Get rid of him. I've lost my slides. What is going on here? Maybe I have to minimize that. Oh, it's here. Oh, this is one of my slides. That's the problem. I need to go to PowerPoint slideshow. That's my PowerPoint. How come I can't go to the next? There we go. Okay. So this is what Faber was talking about. How do we know what the procedure is, since it's so much based on context? And so there is a spectrum of whether or not the administrator has to follow a bunch of rules versus not many rules. They still have to be procedurally fair, but the amount of protection involved could be very little to really, really high. And that's whether something is more administrative versus more judicial. So if it's more that I'm just making an administrative decision, then there's less procedural fairness. If it's something that feels more like that a court makes, that it really is going to affect you in the future, then there'll be more procedural fairness involved. Let me give you an example. If you are coming to Canada on a visa, the the immigration and customs official, I think they call Canada Border Services agent, when you arrive at the airport, they have 100% discretion to determine whether or not you can visit Canada. So they can just decide, we don't believe you're a bona fide visitor, and they can put you on a plane and send you home. At their expense, of course. So, and you will be held in jail until they can find your next flight. They have the right to hold you in jail. That's an administrative decision. And they can't do the same for a person who might have a PR or is a citizen, of course, right? Because those people are afforded much higher protections. Because they're saying that if you're visiting Canada, it's it's not a right, but a privilege to be able to come into the country. But if you're a permanent resident, you have a right to come into the country. And so there's many more procedural protections for a permanent resident. They can't say to that person, see you later, right? Whereas if you're just got it coming in on and it depends on the kind of visa too. If you're just coming in on what do you call it? Just a visitor's visa just to hang out and see the country, that would be different than if you're coming in on a work visa. If you're coming in on a work visa, you'll have more protections in place. But if you're just saying, I'm just coming to visit and have a good time, that would mean that you have very little protection and they have full discretion. So I'm going to tell you guys a bit of a story about this. My wife is from Russia and we got married about 15 years ago. And when she came to Canada, she was pulled. She'd come and visited me. I think it was 3 months earlier, and then she came back 3 months later, and she was planning on staying. And so she came with 2 huge suitcases. One of them had her wedding dress in it, and they pulled her off the line. So she was coming to visit. They, pulled her into one of those interview rooms, and they were asking her all these questions. Like, you were just in Canada. Why are you coming back? Now, if you've ever met my wife, she's a very confident woman, and you'll understand what I mean when I say this. She was like seated with her legs crossed, and she was looking at her nails. She was saying, oh, I just decided to come again. And they actually had a interpreter there for her. And they said, are you bringing into Canada? No, they said, well, why are you coming a second time? She goes, I can come anytime. I can come today. I can come next week. I can come whenever I want. And I just decided to come. And then they said to her, are you bringing anything? And she said, no, just the stuff I normally bring, my clothes. And they interviewed her for 45 minutes. And they let her through. And they never opened her suitcase. Had they opened her suitcase, they would have sent her back, right? Because she had her wedding dress in there. They could have just, if they wanted to, if they opened her suitcase, they probably would have just sent her back home. And that is because it's an administrative decision, whether or not someone gets to come and just visit. Now, it would be very different if she had a work visa and she was coming here to work. There would be a much higher expectation of protection. Welcome. What's your name? Jennifer. Welcome, Jennifer. Everybody, this is Jennifer, in case you haven't met her yet. So, as I was telling you guys, for example, if you got caught with an allegation of plagiarism or academic dishonesty, very serious. It's going to go on your record, right? It's going to be something that's going to follow you around if you apply at other universities. It's actually really, really serious. They can kick you out of the university for that. So that's not administrative. That is very judicial. But when you're applying to go to the school, do you think that that's more administrative or more judicial? It's more administrative, right? Do you have the grades? Do we choose you versus someone else? And so you don't get the same kind of protections when he said that there are some protections, but it's much limited in comparison. They can't arbitrarily decide they can't like put your name into a lottery and say, okay, we're going to pick people out, right? You get to have some sort of protection, but it's not the same level as you would if there was an allegation made against you for academic dishonesty. And so when you look at the considerations, what is the nature of the decision being made? We've talked about that. What's the nature of the statutory scheme so that you're operating by? The importance of the decision to the individual. Well, if you're applying to go to a school and you haven't moved there and you haven't entered the program, the importance is quite low, right? Do I go here or do I go there? But once you're in the school and you're taking the program and you've moved and that an allegation of academic dishonesty could ruin your life, well, that's a pretty important decision. So you would expect different kinds of protections. What are your legitimate expectations? Well, that's partly built on the scheme or the policies and procedures that the university has already created for those things. So you would expect that they would follow those. And then the choice of procedure made by the body itself. So if the university's decided to use this, sort of a board of people who are going to make a decision, it looks very court-like, and they've chosen that, so it's going to be more judicial. So in terms of the context, that's what they mean. If it's something that's going to ruin your life, then you expect it to be very judicial-like. But if it's something that's trivial, then it could be more administrative. And that's not to say that they can still do nothing. It still has to have an element of fairness to it, but it's not the same level of protection where it's something that's not going to really affect you. Now, one of the things he talked about in the video was the right to make oral submissions. If the matter is administrative, typically you don't have a right to make oral submissions. So what I mean is you can make submissions, they're just in writing. If it's more judicial, usually you have the right to make oral submissions. But in any case, if there's an issue of credibility involved, meaning that should I believe you or should I believe you? Who do I think is telling the truth? Then you have to be able to make oral submissions. So if there's issues of credibility versus like he said, she said, then typically they want to hear both of you they want to hear you in person because it's hard to know if someone's lying on paper, but it's much more difficult to lie when the person's sitting in front of you, right? So the two Latin
Professor, sorry to interrupt. Please, we can't see the screen.
You can't?
No, the screen is not shared, I think.
Okay, I thought I shared it. Oh no, it's not shared. That's the problem. Here we are. Now you should be able to see it.
Yeah, thank you.
Okay. So he talked about two different Latin phrases that are attached to natural justice. The first one is audi alterum partem, and that's basically letting the other side be heard. And, you get a chance to present your case, all the things we talked about that. And then the second one is anima judexa in causa sua. No one can be the judge in their own cause. And that's the duty to act fairly and not without bias, and to be transparent, and for everything to be evidence-based. So along with that comes a number of things. So these are the things that come along with that. So you have the right to be free from bias. The person who's making the decision in your case can't have a financial interest in the outcome. It can't be a familial or personal relationship. It can't be a professional relationship. They can't have exhibited an attitude that would lead you to believe that they might have some bias, and they can't be involved in the process. So what do these things mean? Well, family relationship and personal relationship, I think that's obvious. But what is professional relationship? Well, I'm giving you an example. I had a case where the judge at the beginning of the trial said to me, Mr. Batchelor, I worked at your friend. Your friend is what they refer to other, opposing counsel, that's what they call them in court. He said, I worked at your friend's law firm 20 years ago. That's a professional relationship. Do you have an objection to me considering continuing with the case? I could have said yes, and we would have had to get a new trial. But 20 years ago, they don't know each other. He says, I don't know him, but I did work at that firm 20 years ago. So, obviously you're going to be smart about how you call those things, but he had a duty to be transparent and to let me know that he could potentially have a bias. The reason that's important is this kind of bias exists not because it exists, but because it might exist. What do I mean by that? If there's a situation where there's a potential of bias, then there's bias. And you have to act as if there's bias. And so the fact that he was transparent and told me about that, he was doing the right thing. Because probably there's no bias, but it doesn't matter if there's bias, it's whether there might be bias. That's what's important. So when we're dealing with bias, we have to ask ourselves, is there a potential of bias? If there's a potential of bias, that means there's bias, and you have to act as if there's bias, even though there might not be any. Same with attitudinal. So attitudinal comes from the fact that maybe a judge or decision maker has written an article in the past where they say that, international students should not come to Canada, for example. Like they say that we have too many students here, they shouldn't come to Canada. And then you are before that judge. Then you could say, oh, I'm sorry, but I believe that there's attitudinal bias here because you've expressed the fact that you think that international students shouldn't come. I'm an international student, and so I believe that you might be biased against me. And that judge would have to get off the case. Whether or not they have bias doesn't matter. It's whether or not an objective person looking at it could think to themselves, there might be bias. That's all you have to prove. And I think it'd be really easy to prove that one. And then involvement in the process, if you've got any kind of involvement. So the previous place that I worked, I was the coordinator of the program. If there was anybody, let's say a student was accused of academic dishonesty, I couldn't sit on that panel if the professor was one that I was responsible for, because I had involvement in that, even though I might not have any actual direct involvement. But the fact that I supervised that person means that I had involvement, which means that I couldn't be involved in that process. So these are the sort of important parts of the procedural fairness. You have to have notice at the hearing, meaning that you got to know when it's going to be. The question is, are you going to have written or oral submissions? And if there's an element of credibility involved, then you have to have oral. You have to be able to bring evidence. You have to have right to have assistance, to call witnesses, and to an adjournment, if necessary. The decision has to be heard by the person who's heard all of the evidence. So here's an example. I had a client who was accused of assaulting a police officer. We did half the trial, and then the judge had a heart attack and died. So they couldn't bring another judge in to continue the case. They had to start all over again, right? And so because whoever hears the case has to hear the entire case from start to finish. You can't substitute people in. So they have to hear the entire thing. Then you're entitled to reasons. He mentioned that in the video, and you have to have the hearing within a reasonable period of time. So if it's something involving a school, for example, that has to be really fast, right? They can't wait 6 months. It probably has to be within the month. But if it's murder, then it has to be within the year. But I mean, still, it's still. Now, if you are the reason for the delay, then you can't complain about the delay. So if you said, I'm not ready to go, I need an adjournment, then you can't say, oh, by the way, I got a 6-month adjournment and we're a year in, so I should be able to, I should be able to call delay. Well, the judge will say, but 6 months of that adjournment was your request, so you can't argue that, right? So the reasonable time is based on the other side or whoever's responsible for hearing the decision not doing it fast enough, not you asking for extra time. And then if people don't apply fair, natural justice, what can we do? Well, the first one is mandamus, which is an order saying the person has to do it. So when I gave you guys that example of my stepdaughter, I would have been asking for an order of mandamus saying that they have to basically sign the permanent resident documents. Quo warranto, removing a person from occupying the office illegally. That's not a physical office. That is a political office or, a position. And so if the person's not willing to leave the position when they're supposed to, then you can ask for that order. And then judicial reviews. And we're saying we want the courts to look at this decision and decide whether or not the decision was done properly. And that's it for chapter 1. Questions, concerns, complaints? Tequila's here, but she's not in the jungle this time. No questions? You guys understand this 100%? That's amazing. We're all good? All right, so we're going to move on to chapter 2. Yes. When I said about regulations, yes, that can be changed easily. I mean, legislation can be changed, it's just difficult. But you have to go through the political process to do that. So let's say immigration. I'm deciding what the immigration laws are going to be. What's the process for applying for immigration? That would probably be under the legislation. But what kind of documents do you have to provide? That's probably going to be under the regulations. So I can just decide tomorrow, we're not going to take the Nigerian passport anymore. They're going to need to have a Nigerian passport plus a birth certificate, right? That would be under the regulations. But the fact that you have to fill in the application, that you have to go to the embassy and do an official application or whatever, that might be part of the legislation. I can't change that without going to Parliament and asking to do an amendment in the law. So I would actually have to go through the entire process of making a new law to change that. Whereas with the regulations, I can just decide Tomorrow, we're going to do it in a different way. Okay? The difference between statutes and civil law, they're the same thing. So when we're talking about civil law, we're talking about the law on the, now, actually, let me qualify this. So civil law has many meanings. So when we say civil law, it's a type of legal process. So we have civil versus common law. And that's just a different process for civil law is a French approach. So common law is an English approach. So civil law is based on a Napoleonic code. So we have everything written down and we're trying to determine whether or not you've done something wrong based on what's been written. With common law, it's different. But civil law, when we're talking about civil law, we're also talking about the type of law between people. So not with government. So party versus party, individual versus individual, private law. That's what we call civil law as well. So it's confusing, right? If the government's involved, we don't call it civil law, right? We call it public law. And then when we're talking about civil law, we're also talking about law involving codes. So everything's written down. So it's got a number of different meanings. So it depends on the context you're talking about in terms of civil law. That's a really good question because it's very confusing. Any other questions? How about people on Zoom? Any questions? Sarah, you have a question. What's your question?
No, I don't have a question.
Okay, you look like you had a question. I thought, look at that look on Sarah's face. I think she has a question.
I don't.
Okay. All right, so let's move on to the next chapter. Actually, this is chapter 1 and 2 that we did today and last class. So they are in relationship to the slides that we saw there. The definition is, what would you expect to be fair in the circumstances? That's why they call it natural. And that has to do with where things are heard, how they're heard, who hears them, right? So, for example, let's say you get into trouble and it's you versus Francis, and we decide to have the hearing at your house. That would be a breach of natural justice. Even though it's not written anywhere, it's just that would not be considered fair in the circumstances. No, but it gives you an advantage. It gives you an advantage if we're hearing it in a place where you're comfortable versus where he would be uncomfortable. That would give you an advantage. That's what we have, courts are not in anybody's place. And so that would be considered a breach of natural justice. Right. Course content. So the next one is alternative dispute resolution. Gotta make sure I share these. Sure. Okay, I'm going to share the slides now. You guys should be able to see the slides now.
Yes.
Okay, so what is negotiation? Well, I mean, you guys will all have experienced negotiation because it's just part of what we do in our daily lives. And the reason that we negotiate is because, well, let me ask you this. Why would you negotiate?
To obtain something or to gain a benefit.
But why do we negotiate? Like what is the reason?
To get into a mutual agreement.
What if we don't want a neutral? What if I just want you to do it? I say to my son, this is not a democracy. This is a dictatorship. I don't negotiate. Why would I need to negotiate?
To avoid conflict?
You think I'm worried about conflict with my son? Come on, Parasa. I'm sorry? To suit the two parties? Well, I don't care.
I think to come up with mutual goal, mutual saying, actually.
I don't care. With
Oh.
my son, if it's not mutual, it's my way or the highway.
It's dictatories, not democracy.
It's what?
It's not democracy, actually.
No, it's a dictatorship.
Negotiation, it's for actually having more democracy, to hearing other people and putting ourselves instead of themselves, and come up with something that both sides be satisfied.
So very good. So the reason that we negotiate is because we can't get our own way, right? So if we can't dictate the results, then we are left with having to negotiate, right? And so we have to engage in this two-way communication if we can't have our way rule. And so we get the situation where we are trying to recognize the differences in our interests. We're trying to get a compromise or a collaborative effect. Or maybe we're trying to trick the other person. Sometimes we do that, or mislead them and gain as much as possible, right? And we've all engaged in that kind of negotiation before, right? I remember very clearly years ago I was visiting India, and we were in this place called Pune. It's a little tiny hill station outside of Pune wasn't a hill station. The place I was called, I can't remember the name now. Anyway, it was just outside of Pune. It was in a hill station, and in the Mahabaleshwar district. And they had this little market, right? So it was a sort of a night market. And I remember going there, and I wanted to buy some clothing for a friend of mine who was having some children. And the baby clothes were super cheap. Like, I mean, it was just ridiculous how cheap you could buy these clothes for. Like, you know, things that we pay for $30, $40, you could buy for 50 cents, equivalent of 50 cents. And so I was with my friend, and he's from that area. And my daughter went to school there for a year, and that's the reason I ended up there. And so I went, and I was ready to give her the 50 cents, right? Like, it just seemed such a great deal. He goes, oh, no, that's way too much. That's way too much. And so he's telling me to offer the equivalent of 25 cents. And I said, oh, okay. He goes, no, trust me on this. So the woman started to cry. My children are sick. I don't know what to do. And she was like, big tears coming down. I felt so badly. He goes, trust me, let's go. So we walked away, came back like a half an hour later, and she's all smiles. And she goes, okay, 25, like whatever the equivalent of 20. Can't remember how many rupees it was, but very little money. And I bought like, I don't know, maybe like 15 like outfits. Now, I thought about that, and that's what we're used to, right? We're used to trying to get the best deal for ourselves, right? But I thought about that exchange has stuck in my mind over the last many years. And the reason it's stuck in my mind is that when I revisit that mentally, it was very greedy. What I did was greedy. The difference to me between paying 25 cents and 50 cents was not even what I could buy a coffee for. The difference to her was probably a lot. Like, it would have made such a difference to her if she got, instead of $15, $30. To me, $15, like, come on, guys. Like, you can't even put any gas in your car for that price, right? So that has really stuck with me over the years, because I think to myself, sometimes when we're not negotiating properly, it turns into greed. And we're just trying to get as much as we can for ourselves, and we're not actually thinking about what is right. We don't think about what's right. We're just thinking about trying to get the best deal for ourselves. So when I think about the fact of, gaining as much as possible while ignoring the other person's interests, I think that's a good definition of what we call distributive negotiation. And we negotiate all the time. What are we going to have for dinner? What kind of house am I going to buy? How are we going to settle our differences on separation? How are we going to settle this lawsuit? These are all things that we might negotiate about. Now, when should we negotiate? Well, if we're trying to get a result, if we believe that we can't force the idea on the other person or force the resolution, if we've got interests that are compatible, and I'll get back to that in a minute and what I mean by that. If we're in a stalemate where nobody's getting any better and things are getting worse, or if we just perceive that negotiation is the best way to end a conflict. And, it's really interesting that when you look at what's happening right now in Iran, with the United States sitting so close by with the most powerful military in the world, and they're stuck. Why? Because they can't force their solution on Iran, which is something they would like to do, I'm sure, but they can't. And so they're actually in the situation now where they have to negotiate. And I just find this really fascinating, not because it's never happened before, but because it's happened before. And, United States should have known before getting into the situation that you can't go to someone else's country and impose your will. Every time they've tried to do that, it's not worked out well. Vietnam, Afghanistan, Iraq, Libya, like everywhere this has ever happened before, the results have been very catastrophic. People who are trying to impose their will on someone else because unilateral action does not achieve what they want. And when military powers realize that, then they'll probably make much better decisions for themselves. So there are two main types of negotiation, are competition versus collaboration. Now, when you approach it with competition, this is the compromise situation that we talked about. And there's times when that is appropriate. So if I'm going to buy a car at the car dealership, there's no imbalance of power there. I obviously want to get the best deal I can, and they want to get the most money they can. And we're going to be in a competition. And that's typically what we call a compromise. But when we're talking about the future lives of our children after we separate, competition is not the best way to approach that because it's not a win-lose. We want to try to get to a win-win. And I'm going to give you an example of this one. So years ago, I was in mediation with my client who is the mother, and on the other side, another lawyer represented the father. And these parties, I think they've been together for 7 years, and they had a 5-year-old and a 3-year-old. And they just bought their house a couple years before. So there was no equity in the house, right? So basically, if they sold the house, they were going to lose money. And we're trying to figure out, well, what are we going to do with the house? What are we going to do with the kids? And it was my client who came up with this. I just thought she was so brilliant by doing this. She said, let's do this. Instead of having the kids move, let's rent a second place where you, meaning you, her husband, and her would share the rent. It would be a studio apartment. So they were going to do shared custody and shared parenting, where mom would go into the home, the family home that they owned, from Sunday night until Sunday night. And dad would live in the studio apartment. And then the following week, dad would go into the home and mom would stay in the studio apartment. So instead of the kids moving, the parents moved. So the parents would switch residence, because normally what you have in shared custody situation is 1 week with mom, the other week with dad at their respective residences. Well, we flipped it up and we said, Mom, you get 1 week with the kids. Next week, Dad, you get 1 week with the kids. That was such a collaborative solution because what it meant was the kids didn't have to move. And that's usually what causes the most psychological trauma to children is moving away from their friends and their school and all that kind of stuff, right? So they got to stay in the same neighborhood, go to the same school, do all the same stuff. And they didn't, you know, when they were with mom or dad, it didn't matter because they were still around their friends. The other thing is that they kept the house. And had they sold that house, they were going to lose a lot of money. Instead, they did this for, I think it was 12 years. And at the end of 12 years, they had a house with a bunch of equity in it. And they sold that house and they each bought a house. So they were both better off. And at that age, by that time, the kids were old enough to either have been gone or, you know, basically independent. And so that's collaborative, where we're trying to work together to get to a solution that's going to make everybody better off instead of typically what you get in a family law situation is competition. And it could be, I've seen some really terrible stuff, right? I mean, I remember there was one woman who we got her basically everything she wanted, and she did her calculation, and dad was getting the kids 1 day more per year, and she wanted to go back to court to challenge that, right, for an extra day, right? So that's competition, and she wasn't doing it because it was in the children's best interest to do this. She was doing this because she felt she hadn't won because dad had the kids for an extra day per year, right, out of 365 days. So when we're talking about the competitive approach, we say it's distributive in nature, which means that we have a fixed pie, right? So what do I mean by that? Well, if I have, here's some free meals, right? So I got 3 free meals, and I give 2 to Favor. One to Francis. So I've given 2 to Favor and 1 to Francis. Now, Favor, if I tell you to give 1 to Francis, do that, give 1 to Francis. How many do you have? You have 1. How many do you have? So you've lost 1 and you've gained 1. That's distributive negotiation. Whatever I get, you've lost. Whatever you get, I've lost. There's a fixed amount, right? And then we get to the issue of compromise. So how do we make that situation equal? Well, that would be more collaborative. If you're fighting with each other, you're not going to want to use the extra 1 together. What are you going to do? You're going to rip it. You're going to cut it in half or something, right? So you both have the same amount. That's compromise. But the thing is, maybe you want it for different reasons. Maybe you want, Francis, you want the gift certificates because you want to give them away to a friend who's having hard times and doesn't have food. And maybe you want them because you want to take your boyfriend out for dinner, right? And so the nice thing about collaborative negotiation is you can figure out how to make both parties better off. Maybe you make dinner for his friend and take all of them, right? And so he's going to have more food for his friend and you're going to have more coupons to use for your boyfriend. But you can't do that in competitive negotiation, right? Because you're just trying to get the most you can for yourself. You're not thinking about why we want what we want. And so here we're segregating the needs. It's done on a win-lose basis. So whatever you get, I've lost. Whatever I get, you've lost. And you don't care about the other person. You don't care about why they want what they want. You just want to win. So think back to my experience in India, right? Negotiating. Think back to that. I didn't care about her, right? I didn't think about the fact that maybe she had kids and had to put food on the table. It didn't matter to me. I was just trying to get the most I could, which is, a greedy approach. So when we have competitive negotiation, and here's the kinds of things we normally do, which is why I say that it's greedy. We manipulate, right? Now, she was manipulating me, the woman in the market. She was crying, alligator tears, right? Right? She was putting on a show. And so that was to manipulate me. We're only concerned about our own interests, and we're trying to get the biggest amount we can for ourselves. So in the situation that I was talking about with Francis and Favor, if Favor can get all three and Francis can get none, Favor is going to be super happy, right? Because she won it all. And Francis is going to be really unhappy. In fact, with people who are mediators and use this approach in mediation, they will tell you the best mediation is when both parties are equally as unhappy. So you want both parties to be miserable, then you've done a good job. And there's lots of bargaining involved. So this idea of bargaining or positional bargaining is a distributive model. So again, it's based on compromise. It's based on the power or strength of the other party or perceived power and strength. And you're putting everything you can into defending your own position. You'll make concessions. You guys have seen this. So you have an offer, counter offer, and then you try to get to sort of the middle ground, or you may get to a stalemate. And you're going to give up things in order to try to get to a decision. So you're going to give things away, and you're not going to try to get to the optimal solution, but you're going to get to the solution that's somewhere in the middle, which is typically not the optimal solution. The tactics that we use here, we make exaggerated claims, like the woman said about her children being sick, and then that's usually followed by slow concessions. Take it or leave it, our offers. This is, very, very much used in this sort of thing. So I tell you another story of a mediation I was involved with. My client thought I was like the best lawyer ever. He was renting a place, a basement apartment. Actually, it wasn't too far away from my house. And there was a huge fire. The place burned to the ground. There literally was nothing left but ashes of this place. So it literally burned to the ground. And he was in it when it was burning. There's allegations that the fire was caused by him smoking in bed. Nevertheless, he got quite badly burned. He burned his arm and I think it was arm and his leg, but his arm was burned quite badly. And, but he was a tenant. And before we went to mediate, we went to mediation with the insurance company. And before we went to mediation, we hired a fire expert who went through, and he determined that the fire was caused somewhere in the kitchen, which was amazing. I mean, it was gold for us, right? Because personally, I think the fire might have been caused by him smoking in bed. But I wasn't there, so I can't call it, right? So we get to the mediation, and the insurance adjuster, before we even started, he says, "Look, I'm going to offer you $20,000, and if you don't take it, you can just run away because we're not going to settle the dime more than $20,000. It's $20,000 or that's it." And I said, "Okay, well, I mean, we paid for the mediator, so like maybe we could just use today to discover what each other has in evidence, and maybe we can revisit that after we know the evidence that each other's had." He goes, "Well, that's fine, but I'm not giving, you need to know we're not giving you a dime more than $20,000. And of course, my client's getting scared here, right? Because I told him that he should be able to get at least $120,000. So the mediation starts, and then we give him the report. Of course, that changes everything, right? Because if we're going to court with that report, maybe he would win, maybe he wouldn't. Maybe it would be a lot more. At the end of the day, my client got $120,000, right? And so this idea of who has the power can shift very quickly when you're involved in this kind of negotiation. And you can take a take it or leave it, position, but you do that at your peril, right? And you would think back to that situation I told you about with this guy. This wasn't my client, but the guy who was involved in that serious motor vehicle accident didn't accept the offer for 1.3 million and ended up owing his lawyer $10,000, right? So you got to think carefully when you're using these take it or leave it offers, because the consequences might not work in your favor. And then bluffing, puffing, and lying. So bluffing, you're making your position sound like you've got options when you don't. Puffing, you're making it look like you've got more than you have. And then, of course, lying is just flat out not telling the truth. And then threats and warnings, like that insurance adjuster tried with us. Attacking to belittle the other side's arguments. And one of the things that the insurance adjuster said is, we're pretty sure that your client who started that fire, he was smoking in bed. Oh, the other piece to that is that the other piece of evidence we had is that the landlord is required by law to do an inspection on the fire equipment. What is it called? The smoke detectors once a year, and he hadn't done that. And even though my client took the batteries out so he could smoke in the place, it didn't matter because they didn't do the inspection they were supposed to do. So the fact that they had no proof of doing inspections didn't matter, that my client likely took the batteries out of the smoke detector. So the thing about this one is that we've all done it. We've done it with our parents. We've done it with our spouses. We've done it going to buy a car or a house or whatever, right? We've all done this kind. It's easy to participate in. We know what it looks like. We know what to expect. We consider to be acceptable. We can just focus on ourselves. We don't have to think about the other party. And then we have an anchor. So we have a place to start from, right? So that's the people who support this kind of bargaining. That's what they would say. Easy to do, easy to get a result. The people who believe in collaborative or principled negotiation would say, hold on here, it's greedy, it's indecent, it's inefficient. We're not encouraging people to get the best result. The transactional costs are higher. It can damage our relationships with people, especially if we're talking about parents who have to parent for the rest of their lives. We're not thinking about the relationship, and we're not thinking about being creative. Like, how can we create a better solution for everybody? And so there's a new area actually in family law called collaborative family law, where the idea here is that we're not going to try to destroy the other side. We're going to try to make everybody better off. We're going to try to deal with the interests of everybody. We're going to do this on a win-win basis. We want everybody to be better off. Now, when I was practicing law, the woman who was the head of our financial division, I can't remember what her financial coordinator, I can't remember what her job was, but she worked part-time, 2 days a week. Actually, it was 2 afternoons a week. She had 2 special needs children. Both of them were on the spectrum. One severely on the spectrum. She required 24-hour care, and the other one had what they call Asperger's syndrome, which is mildly on the spectrum. She was at the time with a guy who was in the military. He was a captain in the military and made a salary of about $100,000 a year. They got divorced, or separated anyways, and she had no money. He wouldn't pay her anything. Like, he wouldn't give her any money for these 2 really needy kids, unless she agreed to have him have the kids half the time. But he was in the military, in the Navy, and he was gone most of the time. So it didn't make sense to her. So what does she do? She gets a job as a sex worker. So she becomes an escort, right? So that way she can work the hours she needs to work. She can make good money. She can keep the job with me, and she doesn't need this guy's money. And so, of course, he freaks out, and he decides that, not only is he not going to give her any money, he's going to try to get the kids full-time based on her being an escort. So we ended up going to a mediation that lasted 2 days. We had a very seasoned lawyer, very well-respected, probably the top lawyer in the area in family law. And my position was, he can't complain about what she does for work because he's not paying her support. He's basically put her in this position. So you can't not pay support and then argue when your spouse goes and does something to pay the bills. That's legal. I mean, prostitution is legal in Canada, right? So you can't say that she's doing something illegal. She just can't endanger the children while she's doing it, which she didn't. And his position was, well, if she's an escort, then she must be a bad person, and so she shouldn't have the kids full time. And that's just not the way the law works. And we tried to get that. I mean, it took me a long time to get my client to basically say he should have any access to the children, because she thought he was crazy, and maybe he was a bit. Actually, at the end of the day, he was. But you know, I said, well, if we're going to do this, you can't just say, I want the money and I don't want you to see the kids at all. You got to, you know, you got to work towards trying to co-parent with them. And if that works, it works. If it doesn't, it doesn't. So finally got her there, but he wouldn't budge. And his lawyer did him a real disservice because she didn't encourage him to move his position. So we ended up going to trial, and he got decimated at trial. He owed $50,000 in back support, $2,000 a month had in forward support. He got to see the kids supervised for a period of time and then unsupervised, but only for a couple hours. Like, it was just, he got crushed at trial. And I mean, I knew that was going to happen because they're trying to say to the judge, but she's an escort. And the judge basically said, and what's your point? She's doing a job. She's getting paid for it. She's not doing it at home. The kids are not endangered. And by the way, you put her in this position. So, well, the interesting thing about all this, and the reason I'm talking about collaboration is who loses at the end of the day? The kids lost. And why do they lose? After the trial, he disappeared. Nobody's seen him since. He's gone. He's not paying anything, and he has no contact with the children. He's just gone, right? And I just spoke to her maybe about 6 months ago, and this is like 10 years ago, and still nobody knows where this guy is, right? He's got a child support order, and that's probably worth about $200,000, right? And she got about $35,000 through the military through his pension, but he's gone, and the kids have lost their father. And basically for him, it was either I get the kids, or I don't want to see them at all. That was his position, right? And that's kind of really sad for the kids because they've lost a parent out of this. Now, to do this kind of negotiation, you have to have full disclosure. So the idea is, I'm going to give it all to you. I'm going to tell you everything. I'm going to be honest with you. I'm not going to try to trick you. I'm going to be honest. This is a situation that we're in. I need to be concerned about you, about what's going to happen to you. And we're going to try to make the pie bigger. How are we going to make this pie bigger? And we have to work together, which is what's called collaboration. Now, this whole idea of collaborative negotiation or principled negotiation comes from Fisher, Urey, and Patent, who developed the Harvard Negotiation Project. So it's a project out of Harvard. And they actually wrote a book on this called Getting to Yes. And they basically say, hey, if you want to be collaborative and not be positional, you have to separate the people from the problem. And they actually have a really good approach towards this. And they basically say, look, if I'm negotiating with you, I don't have to like you, but we're partners because we got to work together in order to have a solution. If we decide not to work together, we can't get to a solution, and that means that we're going to be going to court. So even though you might not like the person, you still have to see them as your partner because you need to work with them. And then you have to focus on interests and not positions. So what the hell is that? Interests and not positions. And this is the most beautiful part of their model. They say the position is what you want. The interest is why you want what you want. So you want to work with why people want what they want and not what they want. So when I actually teach a course in alternative dispute resolution, and we have a simulation, and in this simulation, it involves this person who is helping their elderly uncle who's lived in the neighborhood for his whole life and is seen as a leader in the neighborhood. And his wife recently died. The house is in really, really bad condition, but he doesn't want to sell the house to someone who's going to develop a business in the area. And then you have the people on the other side who have also lived in the neighborhood for a long time, and they work at the bank, and this company has hired this person to try to see if they can buy the property for a good deal, but knowing that the other party will not typically sell to a business, number one. And number two, if they're going to sell, they have all these conditions that they have to be met. One of those conditions is, for example, you can't change the outside of the house. It's got to stay the same. You got to agree the outside will never change. Now, if you approach this from a distributive approach, you'll never solve it. You just can't, it's impossible to solve it, right? He wants the house never to be changed. They want to demolish the house, not just change it, they're going to knock it down, right? They want to put a parking lot there, right? And so it's just so fascinating because we're so used to this kind of negotiation that usually it's a stalemate. Students can't get to resolution. Every once in a while, I'll get a couple of students who are able to be collaborative, because when you get behind why he wants what he wants, well, he wants it because he wants to be remembered. He wants to keep the neighborhood the same. He's concerned about where the neighborhood is going. But when you find out about what the business does, they have homes for senior citizens. That's what they do. And so, yes, they're turning that into a parking lot, but they also have a senior's residence across the street, which happens to have empty units in it. And a unit is worth 80,000. Sorry, the unit's selling for 100,000, but they can give it to him for 80. It costs them 80 to build. And so if you work on trying to trade a unit for the house, it works out really nicely. And when you think about why he doesn't want to change the outside of the house, the reason is because he wants to be remembered. He wants his legacy to be remembered. So the students who actually solve this problem realize that, and they say, okay, well, how about we put a park in the parking lot, because they don't need the whole area, and we name it after you, and we have a plaque that talks about you and your life and your wife's lives. And when you get to that, it's really easy to see the solution. And the result is that everybody's better off when you do it that way. And so that's an example of inventing an option for mutual gain, right? So we're trying to figure out how everybody can be better off at the end of the day. Now, if you are going to use collaborative negotiation, you have to have ground rules. So, you're going to have to say that, we can't speak badly about each other. We're not going to swear. We're not going to yell. We're going to be careful about our body language. And body language is super powerful. I have another story about this. So when I was practicing law, we went to a negotiation, and the mediation. My client, the only way I can describe him is he was a professional criminal. Okay, so he was a good criminal. But he was a criminal. No question about that. But you know what? He was a good father. Just because you're a criminal doesn't mean you're not a good father. He was a good father, but he was a criminal. The wife didn't want him to have basically any contact with the kids, which is unreasonable because there's very few courts who are going to say that a parent can't have contact with their child. So we're fighting for him getting equal time with the kids, and the kids really loved their dad. There was no question about that. The lawyer, my guard was down in this instance because the lawyer at the time, he was actually a friend of mine. So I didn't have my guard up the way I would normally have it up. And what was happening was I was sitting across the table from him, and my client was sort of sitting across the table from him too. And I wasn't watching what was going on, but the guy was staring at my client. So in jail, when you stare at someone, that's a challenge, right? You don't stare at people in jail. That means like, let's go, right? And so we're halfway through this negotiation, the mediation. My client jumps out of his chair and he says to the lawyer, okay, let's go outside now. Come on, let's go, let's go. And I'm like going, what the hell is going on? Like, what happened? And then I pull my client outside, and of course the mediation gets called off. I pull my client outside, like, what happened? What did I miss? He goes, he was staring at me. He was staring at me, like right in the eye, staring at me the whole time. And the guy, I believe the other lawyer knew what he was doing. He was trying to incite my client to get him to be violent so that we couldn't resolve things because, once you get violent, then that actually works quite very much against you. So we get to court and, he's describing what happened. I'm describing what happened. And of course, the judge wouldn't hear anything I had to say. And so he lost his rights. And since then, I'm much more careful about what's happening non-verbally. That was a big lesson for me, right? Because I realized from that experience, you got to pay attention because how much of our communication do you think is nonverbal? How much is nonverbal? How much of our communication is the words we say versus everything else?
30% is verbal, 70 is body language.
How much did you say, Miguel?
70% or 75 is body language, and the rest is verbal.
Okay, but I'm saying how much do you think is verbal and paraverbal, which includes speed, volume, everything else? How much is just the words, and how much is everything else? What do you think? So you're talking about verbal versus body. I'm talking about everything but the words, including paraverbal.
I think it's very similar, like 80%.
10, 15 is the words? Yeah, it's actually 7%. So 93% of our communication is everything but the words that we say, right? And here, give you an example. I could say, Francis, you're a great student. Or I could say, Francis, you're a great student. I've said the exact same thing, but the meaning is completely different, right? And so, and Miguel is right, 70% is just body language. So if we don't pay attention to that, we're doing it at our peril, right? And so that's why when we're talking about communicating respectfully, that includes things like you can't do this, and you can't make faces, and you can't sigh, and you can't do all those things that we're not actually technically not saying anything bad about the other person, but we are at the same time. No interrupting, and then the use of I statements when we share concerns. So what is that? Well, instead of saying you did this and you did that, which is how we normally communicate when we're arguing with someone, we say, I need this, or I would like to see that, right? So the thing when you use I statements is that nobody can ever say, like, I mean, if Favor says to me, I really am having a difficult time in class because you're not speaking loud enough. I really need to be able to hear the content. I can't say to her, well, no, you don't need that. I can't say that, right? And I won't say that. But if she says to me, you're not speaking loud, you need to speak louder. Well, I can say, well, no, I don't need to speak louder. But if she's saying, I actually really need to be able to hear what's going on, so would you speak louder? I can't say, well, no, I'm not going to do that, right? So it's a very delicate difference, but it's a big difference. And then, well, how do we use these tools? Well, we know that things are going to go wrong, and this is what then the person who's responsible for the negotiation has to do. They have to monitor this and make sure that people are following these rules. Otherwise, it's not going to work. Now, how are we for time here? It feels like we're talking too long. It's three. Wow. Okay, so let's take a break. 15 minutes. Let's come back at 3:15. Are there any questions before we take a break? No questions? You guys scare me when you don't ask questions. I get scared. Should I be scared?
I think that's because we are scared.
Shakila, what's your question? Shakila, can you hear me?
Yeah,
What's your question? Where's your jungle?
remove the jungle.
You moved it.
Yeah.
Okay. So any questions?
No, right now, no question.
Okay. All right. All right. So see you guys at 3:15.
Okay, thank you.
Hey, it's 3:15. So, part of what, if you're going to be involved in collaborative negotiation, and if you're going to especially learn how to be a mediator, then you're going to have to practice what we call active listening. And it's an amazing skill. I wish I had time to teach it in every class, which I don't. It could take several classes to actually deal with this, but we'll just give you the breakdown of what it is. So here you're trying to give the other person your complete attention. You want them to share their thoughts and feelings, and you want to listen, give them phrases to show that you are listening to them. Things like saying, you know, good point, tell me more about that, I see, okay, and you're basically trying to clarify what their needs and interests and concerns are so that you can get to their interests and not just focus on positions. And then you've probably heard counselors do this. They do this a lot, right? Where you reflect back the words spoken. So it's a bit, what's the word I want to think about here? It's a bit weird when you first start doing it because it feels like you're not being genuine. But once you get used to using it, the other person's not going to feel like you're not going to be genuine, and in fact, they're going to really believe that you're listening to them. So, for example, if I say to, I can't remember your name again, Saloni. If I say to Saloni, how was your weekend? So I'm saying to you, how's your weekend? So she said it was really great. And I would then say, so it sounds like you had a good weekend. And she said yes, and she nodded. And that's a typical response, right? Because instead of the person thinking, why, I just said that, why are they asking me that? They will actually respond with, yeah, okay, this person actually listened to what I said because they responded with what I said. And that's one way to show this genuine interest. But it's a skill. It's not it's nothing more than a skill, so everybody can learn how to do it. And when you do it, if you do it well, it will take you a lot of places. It's an amazing skill. We talked about using the I phrases already. So you have to talk about what your needs and feelings and concerns are and trying to separate the people from the problem, and things like I need, I want, I'm worried about, you're talking about yourself and not the other person, and that leads to more collaboration. Any negotiation, according to the Harvard Negotiation Project, has to have 3 criteria. It should produce a wise agreement. So it's got to be something you look at and say, well, that's a good, wise agreement. If it's not, then it's not going to last. It should be efficient, and it should improve or at least not damage the relationship between the parties. So when you are going to negotiate, preparation, there's 3 major things you have to worry about. Number 1 is preparation. Number 2, preparation. And number 3, preparation. Okay? Those are the 3 things you should concern yourself about. And I cannot believe how many people are not prepared going into negotiation. I would say 90%, 80 to 90% people are not prepared. It is unusual to be prepared. But it is the most important thing to be prepared. I take you back to that situation with my client with the fire. If we weren't prepared, we would have probably settled at $20,000. Preparation is the most important part. So how do you do that? Know what your interests are, what your values are, what your timing is, what your resources are, right? You want to know about what your needs are, what your goals are, and what's your bargaining range. What's the least I would accept? What's a good deal for me, and what's the least I would accept? We call this the BATNA, the best alternative to a negotiated agreement. What's the point at which I will just walk away and go to court? What are my alternatives? What if this doesn't work out? What alternatives do I have? Maybe I have to settle, right? What do I know about the other party? So you want to know their target point, right? Your target point. What's the best and realistic settlement for you? What's the resistance point? What's the least desirable but still acceptable solution? And then that's your bargaining range, right? Between your target and your resistance point. And then what happens if things don't work out? What am I going to do? So for example, with my client with the fire, we're going to go to court. If we don't get, I think our walkaway point was 75,000. And if we didn't get that, we were prepared to go to trial, right? And that's the BATNA and WATNA. So the BATNA is the best alternative to a negotiated agreement, right? So what's the best thing I can do if we don't get this agreement? And the worst alternative to a negotiated agreement. What's the worst thing that could happen if we don't come to an agreement? And so the best and worst alternative, they give you a realistic alternative to be used. And if we know this, it's going to give us confidence in the negotiation. We knew that if we didn't get 75,000, we were going to say goodbye, and that would be the end of it. It would be, if nothing else really strange happened, we'd be prepared to go to court, and we wouldn't feel badly about it, and we wouldn't be questioning our decision. So then you got to think about what your opening bid is going to look like. So how do you think you get this? How do you get to an opening bid? How do you arrive at this point? It's probably the most important part of the negotiation, your opening bid. How do you get to this? Well, typically it will be financial just because that's the nature of negotiation at the beginning. So typically it will be. So how do you know what your financial amount for your opening bid is going to look like? The highest amount. So what effect might that have if you go in with the highest amount? No, but let's say, I don't know, we're negotiating over the sale of a house and I'm the seller. And I say to you, I know the house is listed at 1 million, but I really wanted 5. What effect is that going to have on the other party? You think it'll have no effect? It'll have an effect. Well, no, I have shifted my position. It's listed for 1 and I want 5 million. That's a big shift, don't you think? What effect is that going to have on the other party? Ah, so you think maybe I was dishonest. It's going to make them mad. It's going to make them angry. I thought it was 1 million. You're asking for 5 now? Why are you wasting my time? Why are we here? That's what happens, right? If your bargaining range is too high, other party is going to be angry, and it's going to break down the negotiation. So you don't want to be too high. And then if it's too low, it's not good for you, right? So you want it to be good for you at the same time. Now, I was just involved in a really interesting negotiation. I wasn't involved. My wife's a real estate agent, and she was selling a property, which she ended up selling. But it was fascinating to me as a person who's interested in negotiating, because here's what the parties did. They're selling a commercial property, and this commercial property has this thing called a mezzanine attached to it. So the mezzanine is kind of like the stairs going up, and then you got an area higher up, right? But this is a physical structure that's bolted in. Whoa, sorry about that. It's a physical structure that's bolted in, and it's a huge thing, right? It's a big, huge structure. So they're asking $1 million for this property, and then the guy makes an offer, and they say, okay, well, we'll accept your offer, but that does not include the mezzanine. So they were planning on removing the mezzanine and selling it separately. And this whole negotiation became about the mezzanine, which is not, it distracted everybody about what the negotiation should actually be about. right? So they got focused on this stupid mezzanine. I mean, we were joking afterwards, right? Because it was such a distractor to what the parties were actually trying to achieve. And eventually, I said to my wife, get away from the mezzanine. Don't talk about it at all. Just talk about the price, especially with your client, because the client started getting angry. So he's saying, like, they're going to remove this thing, which is going to take a couple transport trucks to put in and sell it to someone else for $40,000. Like, this is getting, like, and everybody started getting angry about this mezzanine. So part of what you need to think about is try to make the negotiation clear and transparent, because I think what they were trying to do is getting a little bit of extra money. They ended up getting the same money, and in fact, not only did they get the same money, but this real estate agent then, with my wife, she's trying to negotiate the commission. She's trying to say, well, that if they're not going to move on the mezzanine, like maybe we should reduce our commission. And she said, I'm not reducing the commission. It's 2.5%. And it wasn't a good one. It wasn't a good strategy. Because I said to my wife, it's 2.5. It's 2.5, it's 2.5. If she wants to reduce her commission, good luck. You can do that. You don't need to reduce yours. You're on the buyer's end. Buyer doesn't pay commission. It's the seller that pays commission. So it's 2.5, leave it at 2.5, and she did, right? So the negotiation was, and then she's trying to say to my wife, I was listening to this telephone call, it was on speakerphone, and she's saying, well, I think we should both give up something. I'm a high level producer, and maybe just even like 10,000. Like, let's just each give up 10,000. I'll cover half the cost of the mezzanine. And I'm going to my wife, no. And she said, no, I'm actually not prepared to do that. And she said, well, I'm going to give up something. How about I give up 5,000 and you give up 5,000? And my wife says no. And so they got down to, well, maybe you could give it as a gift to your client, right? So maybe you could just say, I'm going to reduce your cost by 2,000. I'll reduce 2,000. And then she said, you can do what you want. If I want to give my client a gift, I'll do that. You can do what you want with your commission, right? So at the end of the day, she was really angry. The woman on the other side got really angry with my wife because she wasn't willing to give up anything. But the problem was she created this problem by getting into a negotiation where they weren't transparent about what they're looking for. Because the place was listed before at 1.15 million, and they've reduced it to 1 million, but then they weren't going to include something that's called the fixture, right? You don't sell a house without the roof, right? Nobody does that, right? It would be like trying to sell the house without the roof. Sure, I'll sell you the house for 500,000, but I want an extra 100,000 if you want me to throw the roof in. Otherwise, I'm going to take the roof out and sell it to you a house with no roof. That's the same idea. So it's bad faith negotiation because you're not really being transparent about what it is you want and what you're trying to get out of the deal. And so part of the opening bid involves being transparent about what it is you're looking for, right? And recognize that if you're really aggressive, dealing with someone really aggressive, they might ask for something that's ridiculous. So you can't control what they're asking for. You just have to know ahead of time what you want, which is what I said to my wife. If you're going to do this negotiation, you should already know ahead of time what you're willing to give up. And at the end of the day, after we talked, she said, I'd be willing to give some money to my client, but I'm not going to tell her that. Right? I would normally give him a gift anyway as a client, so I'll just throw in my contribution towards the mezzanine as his gift. But I'm not going to let her know that. I'm not telling her what I'm doing. So she knew what she wanted, and she knew what she was willing to, she knew what her target range was. She knew what the resistance point was. And that preparation helped her to be more confident, because this woman is a very experienced real estate agent, and she was trying to push her weight around. While I'm so experienced, I've done these deals all the time, blah, blah, blah. And I said to her, that doesn't mean she's a good negotiator. Just because you're sold a lot of real estate doesn't mean you're good at what you do. And that's the truth, by the way. doesn't mean you're good at what you do. So once you've done these 4 points, then you've got to think about the other party's positions. So what's their target, resistance, BATNA, and WATNA? And once you've done that, then you got to think about, am I prepared? Do I know my walkaway point? And that will give you so much confidence. If you've done this and you're well prepared, you're going to have a lot of confidence. And people won't be able to push you around or sway you. And I think one of the reasons in this negotiation with my wife and this other real estate agent who is a high producing agent, has lots of experience, she got frustrated because I think she thought she was going to push my wife around because my wife is fairly new. And I think she thought that it would go very differently than it did. But my wife had the confidence because she was very prepared for this negotiation and she knew what her client wanted and what she wanted out of it. Now, the other thing you need to think about is your worldview. So what are your beliefs, attitudes, values, culture, right? What's your identity? These are things that are difficult to change, right? And it's going to affect our expectations. So what's important is to know who you are, not that you're going to change it, just to know who you are and what your expectations are and recognize that that's going to become part of the negotiation. And the mood can be cooperative or competitive. That's typically set up by the parties. It was really interesting because, again, going back to that negotiation with my wife, she was being very cooperative at the beginning until she realized that my wife wasn't going to budge. And then she became extremely competitive to the point where, when my wife wouldn't take a lower commission, she made a comment like, well, when this is all done, we'll go to Tim Hortons and have a coffee. Right? Which was kind of a subtle message. She was kind of saying, well, if you don't want to reduce your commission, means you're poor, and so the best you can afford is Tim Hortons, right? That's what she was getting at. Because then at the end, when everything was said and done, she goes, well, we should go out for a nice dinner somewhere, right? The most important thing is to recognize that positions are separate from interest. Just because someone says they want something, what you want to know is why they want it, because maybe you can find another way of having them get the same thing and getting a better deal. And also know that people who are really competitive are going to inflate their position and they're going to say it's non-negotiable. So they're going to say that this is it, I'm not going to move, and almost always they will. When you're dealing with someone who's collaborative, then they're going to be very clear and honest about what they're looking for. Again, with needs, you want to remember that positions are what you want, but interests are why you want what you want. And it's important to know that distinction. And so if you're going to be collaborative, you have to be able to sort through positions and needs and recognize that you want to know what these positions are, the interests are. You want to understand what the interest is. You want to address people's interests, and you want to meet them to the best degree possible. And so one way to move from being competitive to collaborative is by refocusing it, again, from positions to interests or needs. And instead of trying to get as much as you can, you try to think to yourself, how can we each contribute to meeting the priority needs of both parties? We're trying to meet everybody's needs instead of just one party's needs. Other things you need to think about is where the negotiation is going to take place. So typically it's done in a neutral location because it gives a party, you guys, anybody here watch sports? Anybody here follow sports? No sports here? What's going on with you guys? Nobody follows the Montreal Canadiens, the Toronto Maple Leafs, Ontario Football Club?
Yeah, I follow football or cricket
Oh,
and
so
Formula One sometimes.
you follow the Toronto Football Club, TFC?
No, not this. I follow just Barcelona, Real Madrid.
Okay. All right. So if Barcelona, who are your favorite teams?
Barcelona.
And who's the second favorite team?
Second favorite team is Man City,
Who?
Manchester City.
Oh, Manchester. So let's say Barcelona's playing Manchester in Manchester. Who's more likely to win?
Manchester,
Why?
because it is their home ground and the audience are their club fans, and they'll be cheer for the Manchester.
Yeah, we call it the home team advantage, right? So that's why with negotiation, Favor was asking earlier why it would matter. You have a home field advantage when you're negotiating in your comfortable space. And so we know that from sports. When you're playing a game in your home turf, you're going to have a better chance of winning than the visiting team. And that's well known in sports circles. And it's the same thing in negotiation. If I'm negotiating with you and it's in my living room, I'm going to be comfortable. You're going to be uncomfortable. I'm going to have an advantage over you. So part of what you want to do is try to get a neutral location so nobody has that advantage. And then you want to have an initial meeting before the negotiation starts where you can just talk about, well, what's the agenda? How long are we going to, how long is this going to go? It doesn't have to be in person. It can be over the phone. Is it going to be the whole day? Do we need to worry about lunch? All those kinds of logistical issues. Is everybody there? So I had a negotiation that was really difficult. We went through the entire day, and at the end of the day, we asked the mediator asked at the beginning, is everybody here? Is everybody here have the right to make a decision? Do you need to consult anybody? Can you make the decision for yourself? Everybody said yes. We got to the end of the day. We got to an agreement, very difficult one. And then the other party says, oh, I'm not allowed to do this. I have to go check with my boss. I don't know if I can do this. We all just went, oh my God, what have we been doing all day? Right? So you want to make sure that everyone's represented and everybody has the authority to make the settlement. Does anybody have any physical issues that has to be addressed? What's the agenda? What are we going to cover? What are the ground rules? And is there washroom facilities and refreshments nearby? Kind of important, minor but important things. And it's okay to let the other party know that you're concerned about them. They're your partner, as I said. So, I try to start off by saying, to show that we're not enemies. We're partners. We're here to try to resolve a situation. Difficult to do with lawyers because lawyers tend to think they're enemies, but you don't have to be an enemy to solve a problem. Show that you've got a willingness to change. So you're flexible. That you're here to solve problems and that you're here to have open communication. Now, bad behavior in negotiation, so attacking and evading, right? That's bad behavior. We want to focus on being opening, informing, and uniting, and not attacking or evading. Now, in the Coleman-Rader model, one of the models of negotiation, talks about this first stage being ritual sharing. So when you get together with someone in a meeting, what's the first thing you do typically? Like if you're going to negotiate with someone, what's the first thing you do? What's the absent? I'm sorry? Greet. And how do you do that? Shake hands and then what? Yeah, right? You don't say, okay, so my position is, yeah. Oh, Favor, nice to meet you. Nice to meet you, Favor. Okay, so our starting bid is, nobody does that. You talk about the weather. You talk about Barcelona and Manchester. You talk about, I mean, in Canada, it's the weather, right? That's where everybody's, oh, terrible weather today, right? Every day is a terrible weather today. And everybody agrees. That's something you can actually agree upon. The weather is not good. It's either too hot or too cold. Or that in Toronto, it's the traffic, right? The traffic is terrible. How is it? People always say, how was the traffic? Oh, traffic was terrible, right? And you can talk about how terrible the traffic is. That's really important. And the reason that beginning is important is because it actually allows you to agree upon something. So you're setting the foundation that we can agree on something, even if it's something as simple as the traffic or the weather. We call this ice breaking, and it makes us more comfortable with the other person. it shows that we can agree, we can work together. And part of this is not just what we say, but again, it's the nonverbal part, right? So if I'm asking you about the traffic and I'm looking in my eyes like, oh, that sounds like it was really difficult getting here, right? There was 2 accidents on the QEW and you know, the traffic, that sounds really frustrating. You can actually start to develop that active listening and show non-verbally that you care about the other person, which is the beginning of a good negotiation. There we go. And then we start with stating our positions. So this is, notice it doesn't say interests, it says positions. So what's your position? So what you want, right? And then you can then start moving from the positions to the interests. But typically we're not going to say why we want what we want. We're just going to say what we want. And then we get to, as I said, the underlying needs or the interests, right? So you're trying to be open, you're trying to be probing about what their needs, values, feelings are. You want to use active listening, you want to summarize what the person's saying, and you want to demonstrate that you care about them. You don't want to be fake about it, but you still want to demonstrate it. And then we want to try to unite in a direction. So we're trying to find win-wins, right? Where we can both win. And then we go into problem solving. We're going to brainstorm, right? So what is brainstorming? Anybody know? What's brainstorming?
Thinking about something before it happened and actually considering cons and process. Actually, advantage and disadvantages.
Right. So with brainstorming, we're trying to come up with as many ideas as possible. And with brainstorming, we don't care about whether or not they make sense or not. So the idea is quantity, not quality. So as many ideas as possible, because you can use those ideas to get new ideas. Even if something's ridiculous, it might turn into something that's reasonable. So that's what we're doing here. We're trying to free think, come up with as many ideas as possible, and then we can choose out of those some that actually make sense under the circumstances. And then hopefully, we'll get to this point where we can reach an agreement, right? And then we can hopefully document that agreement and walk away with an agreement. Now, mediation, that was negotiation. The difference is with mediation, we have a neutral third party, and that party has no decision-making power. They're powerless. The only reason they're there is to be a referee. Why would we need a referee? Why do we need someone there who can't make any decisions? To avoid, well, we're going to have bias. If it's me against you, I'm going to be biased in my favor. What do you mean by that? To avoid conflicts? Tell me more. That's right. So it's to reduce the unnecessary conflict. So for example, Favor's my ex-wife. We're in a meeting together, right? I've seen this happen a million times. So what's the first thing that comes out of her mouth? How's the new girlfriend? And what do I say to her? Way better than you ever were. That's the road we're headed down. Now, without having a third party, typically that'll just end up in a big fight. We'll walk away, nothing will get resolved. If you've got a neutral third party, they can say, come on, Favor, like that wasn't really fair. And Roger, that wasn't fair either. Let's try to blah, 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 right? Getting the parties on the right track. And that helps us to kind of, you know, if you've got someone who's really skilled, who they can do it very well without making us feel like they've insulted us or made us feel bad, then that usually is enough for us to work together. Because when you have parties with significant conflict, it's going to be really hard to talk and really hard to stay focused and really hard to not insult the other person and call them names and yell at them and shrug your shoulders and go, oh, right, here we go again. It's going to be really hard to do that because the reason they've got a conflict is because they couldn't solve that stuff from before, right? So why do you expect them to be in a conflict again and act differently? Of course, they're going to act the same as they always have, which never worked. And that's the reason that you're here. And so with the mediation, we have this third party who's there. And I want you to understand, I don't know why students have such a hard time with this. The mediator has no, and I mean no, ability to resolve the solution. The mediator should not even make suggestions about how to solve the problem. Why? What happens when a mediator makes a suggestion and it doesn't work out? Parties don't accept responsibility. Well, it was a mediator's fault. They told me to do that. Now, a good mediator can lead people down a path where they make a decision for themselves with the help of a mediator, saying such things as, so what do you think would happen if you did this? And then the person thinks to themselves and they go, oh, maybe, you know what? That's not a bad idea. I think maybe that's a good idea, right? And now they're making the decisions for themselves instead of the mediator saying, I think you should do this. Mediators should never say that. They should never tell people what to do. They can guide them. They can offer suggestions, but never make recommendations. The other thing they can do is they can say, well, if this were to go to court, this is probably what the judge would do, right? So they can tell them what the likely outcome is, but they still shouldn't tell people, do this or don't do this. So the first stage of the mediation is what we call pre-mediation, where the mediator, typically the mediator will do this in one of two ways. They'll ask the parties for a mediation brief, where the party basically outlines in a document what their position is, or good mediators will actually meet with the parties and just basically hear what they have to say. What's the benefit of that? Why is it important for the mediator to meet with the parties if they can? Oh, that doesn't really matter. In the mediation brief, they can basically say what they want. It's not really to them to get information that way. So why else? And you guys at home with your videos, you can respond too, right?
Because you need to hear both sides of the story.
But they are not going to play any credence to hearing both sides of the story. That's not the purpose. I'm sorry? Well, that's part of it. They're setting the ground rules, but there's a bigger piece here. What do I want to meet with both parties separately as a mediator?
So they can listen without being influenced by the other,
So who can listen?
the mediator.
Okay, and what are they listening for?
Well, it's a conversation because they need to listen to whatever the person needs to say, but also the person needs to listen what.
It's not really to listen
Advice.
to them in that way.
Okay.
So it allows the mediator to evaluate who they're dealing with. Because if you know what kind of person they are, you'll know what strategies to use in the mediation ahead of time. So if I've got someone like Francis who's really quiet, doesn't really say much, I know that in the mediation, if I've met with him and I can see he's kind of laid back, doesn't really like to talk much, I can know that in the mediation, I'm probably going to have to try to pull him out of that. So I'm going to have to ask lots of questions, right? Or if I'm dealing with someone like Favor, who's very verbal and likes to make her position known, then maybe I'm going to have to sort of pull the reins on her a little bit in the mediation so that Francis has an opportunity to talk. It's basically allowed me to develop my own strategy as a mediator. That's all it's for. Because you're not going to make any evaluations about the strength of the parties' positions or interests when in the pre-mediation, right? So you're just trying to figure out what the lay of the land is. That's all. What kind of problem is this? What kind of people am I dealing with? That's it. You're not going to make any decisions or make any evaluations about the strength of each party's position. So some of the things you're thinking about do the parties even want to mediate? What am I dealing with? Are they just doing this because they have to? In some jurisdictions like Toronto, you actually have to mediate. Do I want to take this case? Are these people crazy? Like, do I want to deal with this? Is this something that's going to trigger me? Do I have something in my past? Maybe the person looks like my ex-wife and they remind me of my ex-wife, and I don't want to deal with this because I know that I'm not going to be able to be unbiased. Are there language or cultural barriers that I have to think about? Maybe you need to have another mediator present. Are there domestic violence issues that I have to be concerned about? When and where is the mediation going to take place? Is it the right place, the right size? Do I need to think about physical violence? Do I need to think about whether or not one party is going to intimidate the other? Am I going to need to have refreshments there? Do I need to have lunch? Is it likely going to go over lunch? And then I already mentioned that they may or may not ask for a mediation brief, which contains the written submissions. Again, they shouldn't be lengthy, and the mediator should not make any evaluations based on them. Exactly what I was saying. Mediators should not come to a conclusion based on the brief. It's just to let you know what kind of conflict this is here, what's the history, what's the best form of mediation, what kind of people are we dealing with. That's it. And then we want to have an agreement to mediate. So if you're a mediator and you're getting paid, you want this. Why? Because without this, you won't be able to enforce your payment. The person could just say, well, I thought you were doing this for free, right? Where's the agreement? Well, there's no agreement. I just thought you were one of those people who just kind of did nice things for other people, right? And maybe you are, but you can't pay for the bills with that. So the other reason you want to have this is that the agreement to mediate will also contain a clause that says that you can't compel the mediator to testify in court. Now, that doesn't mean that they can't subpoena you. Either party can subpoena you. You will have to go to court if there's a subpoena. You bring your agreement to mediate, and you can just say to the judge, I kind of have a preliminary issue here. The parties did sign an agreement to mediate. It said they weren't they agreed not to compel me to testify. I followed my subpoena. I'm here today, but I would ask to be excused, and you will be, right? Because if they agreed they're not going to call you, the court will respect that. But if you don't have an agreement to mediate, you will have to testify, and you don't want to do that as a mediator. It's a very bad position for a mediator to be in. So again, you will start with your introductory remarks, welcome everybody, talk about the weather, talk about Manchester versus Barcelona, as long as another party is really, I mean, obviously, if one party is really for Manchester and the other party is for Barcelona, you don't want to bring that up, that's for sure. Get parties to sign the agreement to mediate, talk about the ground rules, and then allow each party to sort of do their opening statement, which says why they're there. You're going to want to have these ground rules, which will talk about things like respect, active listening. Caucusing is when, as a mediator, from time to time, you will meet with each party separately outside of the mediation room. And we call this caucusing. And you'll tell the parties about that prior to it happening so nobody feels that you're being unfair. And you'll try to spend as much as possible equal time with each party. And then you'll also tell the parties that you have the right, and they have the right, to terminate the mediation at any time. So they can just cut it off. What you will say as a mediator is, if you are going to terminate the mediation, I would like to have a few minutes with you before you leave, just so we can discuss, why and how, and, if we can continue. And you can even say to them, I will try to get you to stay, but if you're not willing to stay, then it is your right not to be there. No. Fees are done on a session basis. So you get a fee for the day. Every session you would sign a different agreement, and it would have the fees contained in it. So typically it's like $2,000 to $3,000 for a session. Yeah. So if it's a day, right? So if it's a day, you do two. Like if you're doing it under the court also has their own mediation program. Those fees are set by the court. And it's typically like $500 for 3 hours, something along like $600 for 3 hours. But if you're doing it private, then you'll set your own fees, and it'll typically be $2,000 to $5,000 for the session, which would be for the day. And if parties walk away after 2 minutes, you just made $5,000 for nothing. Again, you will want them to also talk about terminating, let them know that they can leave when they want. And the parties are going to want to tell their story. And this is probably the most difficult part of mediation, because what's going to happen, again, Favor's my ex-wife, and she's going to talk about all the terrible things I did, right, as part of her story. And it's going to make me mad, right? It's going to make me mad. Natural. When the party's talking about the conflict and why they're there, the other party's going to get angry. And what are they going to do when they get angry? They're going to interrupt, they're going to swear, they're going to roll their eyes, they're going to do all the things that they would normally do when they're angry. The mediator has to try to prevent this from happening, because if they can't do that, you're not going to get a resolution. So they have to try to let the other party tell their story while the other party is respectful and gives them an opportunity to tell their story, and vice versa. A skilled mediator does this very well. A novice mediator usually doesn't do it very well. It takes experience to get to the point where you can let the party tell their story without insulting the other party. The mediator is a cheerleader. They're there to be positive, to try to get parties to solve their problems. And they're also there to summarize the narratives and maybe even get other parties to summarize their narratives for each other. They will, and this is what I was trying to get at earlier, the mediator is concerned with resisting the urge to frame the issues for the party or manipulate the content. So they're trying to get the parties to maybe get out of zero-sum thinking, but not tell the parties what to do. They're not there to tell the parties what to do. And so they can maybe frame the issues, and this is what I was talking about earlier. So what you want to discuss is, and is that right? Right? So you're trying to get parties to confirm what it is, they're like to reaffirm their statements. So again, Favor is with me, and she's saying, you're a loser. You were never there as a parent. I'm much better off parenting without you. And the mediator is not going to say, yeah, you're a loser. Right? The mediator is going to say, well, it sounds like what you're saying, Favor, is that you wish that Roger was there more and contributed more to the parenting. And what's Favor going to say? Yes. She's not going to say, oh, no, he's a loser. She's going to say, yes, that's what I was saying, right? And so a good mediator will be able to get the party to reframe their statements in such a way that the other party can actually hear what they're saying. Because I'm not going to listen to the fact that I was a loser. I might listen to the fact that maybe I wasn't there enough. And I probably acknowledge that I wasn't there enough. I recognize that, and I'm willing to accept that and state it. But I'm not going to say that I was a loser, right? So a good mediator will be able to get people to reframe the issues in such a way that the party can actually hear it and listen to it. So here's just an example. So what you want to discuss is how you might be able to receive more of Mr. Manager's time and more appropriate forms of recognition for your good service, where the person probably said something like, my manager's, he's a big bully. He just pushes me around and doesn't listen to me, right? And so the mediator will respond with something as like, so what you want to discuss is how you can get more of your manager's time and more appropriate forms of recognition for your good service. And the person's going to say yes. When you do this, the party has to completely agree on what it is that the mediator is saying. So you want to make sure you get the party's approval by them saying yes. And then when you're dealing with issues, you start with ones that are easy to resolve, and then you get to the more difficult issues later. Because when you have something that's easy to resolve and you get the parties to resolve it, you can show the parties that they can actually work together. They can actually, this is not that hard to do, even though it might be, but you can show them that they can come to agreement on some things, which means we can agree on most things, and it's now 4 o'clock. So I'm going to stop there. We're close to the end, which is good. So 57 of 69. If someone can remind me, that's where we left off today. That's where I will start on Monday. And I want to take attendance before we go. So, like I said last time, I'm going to call your name. When I call your name, please just type into the chat either here or absent, okay? And that way I'll know whether or not you're here or not here. Well, it's not course content, it is under, and you guys should have already received the invitation to the next Kahoot.
Yes, we received it. I
Okay,
received it.
good. Okay, so let me now do this so that I can see both at the same time. Here we go. Okay, so Rebecca. Rebecca, no, not here.
Present.
Oh, there you are. Welcome, Rebecca.
Thank you, sir.
I gotta try to find my, there we go. Okay, so Rebecca's here. Present. Favor's here. Parisa's here. Jose.
Yes, I'm here.
Okay. Shilpa. Not here. Andona is here.
Yeah.
Muhammad Tamur. He's here. No, he typed president. Nachikit. Here.
Yeah.
Laviana. Present. Sarah. Zinshu. Manisha. Saloni is here. Nilofar is here. Thi. Okay. Tasnim. Not here. Francis is here. Jennifer. Okay. Shakila's here. Smriti's here. Muhammad Abdul. Here. Keegan. That's you? Okay. Zayam. Bridget. Katerina's here. Evelyn. Evelyn! I know Evelyn. She's not here though. How dare she miss my class? You can't miss my class when I know you, Evelyn. That's not good. Oh, did she? Okay. Okay, we'll give her a break today, but she better be in the next class. Okay. Renee? Ziu? Not here. And Ramadan. Okay, Yusuf is, should you prefer to be called Yusuf or Ramadan?
Ramadan, actually.
Okay.
Yeah, thank you.
Okay, so I've given you guys some things to think about. I would recommend that you consider watching that video that we actually had from last class on the difference between arbitration, negotiation, and mediation. And I think it might also be in the Kahoot, I can't remember. And we'll see you guys next week, Monday.
See you, Professor. Thank you for everything.
Okay.
Thank you,
Bye.
Professor.
Thank you.
Bye.
Thank you, Professor. Bye.
Thank you.
Thank you.
Bye.
Bye.
I'm going to stop the recording first.